Welcome to this employer compliance webinar on managing a performance management process, presented by Employer Pro, empowering employers through effective people solutions. My name's Kent Duffy, employment law specialist and director here at Employer Pro. Employer Pro at a glance. Employer Pro protects employers via effective people solutions. We offer a cost-effective membership model with optional benefits. We have a suite of legally compliant employment documentation, from guidelines, webinars, walkthroughs, and templates for managing key employment processes. We offer employer support, assistance, and representation. We assist employers to navigate workplace compliance and employment laws. In terms of an overview, on this webinar about managing a performance management process, we'll be looking at what is a performance management process, the key legal considerations and risks that an employer must have regard to when considering a performance management process, the importance of a performance improvement plan or a PIP in the context of a performance management framework, and an employee's substandard performance, along with the consultation process and the required steps or the key steps in managing the process properly in accordance with the law, along with Employer Pro's resources for managing a performance management process, including templates, step-by-step guidelines, and resources that we have available for our members. And finally, practical hints and tips for employers to consider when embarking or implementing this specific type of employment process to address concerns relating to an employee's substandard performance. What is a performance management process? It is a formal employment process used to manage an employee's substandard performance, which typically follows informal methods to address performance concerns. It is a process that is appropriate to consider using where there are real or genuine concerns about things like quality, outputs, mistakes, missing deadlines, failing to meet KPIs, etc., that is associated with the work that an employee performs. Essentially, it is a structured framework including reviews of the employee's performance at regular intervals and progressive warnings issued under a PIP for substandard performance, up to including termination of employment in the event the employer can document and prove that the employee's performance remains substandard, or there are deficiencies associated with the employee's work or outputs, etc. The key for an employer to get right when managing this process, like any other employment process or formal process, is the importance of a procedurally fair process. And this includes consulting with an employee about implementing a PIP, performance improvement plan, reviewing their performance at regular intervals, and a structured formal process including the issuing of formal progressive warnings for continued substandard performance. Read Employer Pro's comprehensive ebook on managing a performance management process for more information, including detailed step-by-step guidelines, information, practical tips and walkthroughs, along with template letters for navigating this particular employment law process. Key legal considerations. The Employment Relations Act 2000, notably Sections 4, which deals with good faith, and Section 103A, which prescribes the legal tests of justification, are key to navigating a performance management process, just like any other formal employment process under New Zealand law. So fair process is paramount. Again, refer to our ebook, the step-by-step guidelines and template letters and the template documents associated with this area when embarking or implementing a performance management process. By way of a summary, the sort of key considerations that an employer has to have regard to in this context include, as a starting point, identifying the performance issues and how performance is to be assessed or managed. This is a really obvious one, but a point that is often underestimated by employers. So taking some time to document, be clear on the issues and how the employer proposes to monitor, measure and assess that. Then the next step would be formally notifying the employee of concerns. Here the employer would be proposing a PIP, what that looks like, spelling out everything of relevance or significance to the employee, and following all the usual procedural formalities when implementing a employment process. Again, the procedural aspects or formalities are detailed in the ebook at a great length, which can be referred to and are very useful. The other considerations at a high level is providing the employee with a reasonable amount of time for them to improve their performance. And that question will be informed by the specific nature of the work or role that the employee performs. But an end-to-end performance management process is going to take the employer an amount of time, potentially a period of weeks or months, to navigate that sufficiently end to end. So that includes consulting with an employee about the potential of establishing a performance management process, what that looks like, how it will be, their performance will be measured and assessed, the relevance of structured review meetings and the possibility of progressive warnings being issued at regular intervals throughout the duration of a PIP, up to including termination of employment in the event that the employer can prove that the employee's performance remains substandard. These sorts of considerations an employer has to have careful regard to and conduct a level of due diligence. Implementing the structured framework, I mentioned this before, via the Performance Improvement Plan or PIP to manage the performance concerns. And like I said earlier, this includes progressive warnings for continued substandard performance or the employee's performance failing to improve. Key legal risks at a very high level. So where employers get it wrong or fail to adequately, sufficiently, or correctly manage a performance management process or formal process to address an employee's substandard performance, then it can risk exposure to successful personal grievance claims and other legal claims. So potential remedies on the cards here at a high level is the standard things like injury to feelings compensation or so-called humiliation, lost wages, legal costs. Potentially there's also the risk of permanent reinstatement where an employee wishes to be permanently put back into their job should they believe they have a case for that, along with penalties for things like breaches of good faith, etc. Other practical considerations or risks to take into account is the reputational consequences associated with litigation. So often cases in the Employment Relations Authority and the Employment Court are a matter of public record and are frequently reported on by various news media outlets, along with the practical aspects like management time and stress with dealing with litigation. These are all things to have regard to as an employer when contemplating the potential risks associated with a contentious or protracted employment dispute. The importance of a performance management plan. A performance management plan or improvement plan or PIP is used to objectively assess and identify an employee's performance against. An employer must be able to measure the employee's performance, and any performance objectives set should be SMART or specific, measurable, achievable, realistic, and time-bound. Any performance standards or requirements should also be consistent with the employee's job description. So that's something to have careful regard to when considering a performance management process or framework, is that really you should be doing a cross-check of the employee's job description and using their job description to inform what goes into any proposed PIP, which then needs to be consulted with the employee about before it is implemented. The PIP must provide the employee with a reasonable period of time or opportunity to meet the performance standards or requirements, and like I said before, that's going to often take a period of months. It is a performance management process, so it does require quite a significant effort on behalf of the employer to manage the employee's performance, including all the various steps and requirements that has to go into this process. So consulting with the employee about establishing a PIP, right through to holding the review meetings at regular intervals to assess the employee's performance against the preceding period, and of course making any findings on an informed basis, which would then inform whether or not any formal process for issuing warnings for continued substandard performance is justifiable or not. And then only after the employee has been provided with that reasonable opportunity to meet those whatever those standards or requirements are, could an employer legitimately consider terminating their employment on the basis of continued substandard performance following the process at the appropriate point in time. So time and resource and due diligence are key aspects that the employer must be prepared for and have regard to when embarking on this particular employment process, which is very onerous. The importance of a performance management plan. So just some general practical comments and tips here. So once an employer has taken informal steps to address performance concerns, there has to be that period where the employer works with the employee in good faith, informally, to address performance concerns and try and come up with practical solutions for them to meet the grade or improve their performance. Only after the employer has done that, there's been sufficient period or time there for the employee to informally improve their performance, then, well, if their performance fails to improve, the next step would be for the employer to consider implementing a PIP, performance improvement plan. So generally there, as the employer, you're looking to prepare a draft PIP for consultation that clearly identifies the areas of substandard performance associated with the employee and their work, including how performance or their performance is going to be measured and assessed under the PIP. And then formally consulting with the employee about implementing the PIP, the consultation must occur before establishing the PIP. And like I said earlier, the ebook on managing a performance management process has the various steps and frameworks, template letters, guidelines for managing these components or aspects of a performance management plan or framework. The PIP needs to provide a structured framework for reviewing the employee's performance against, including setting formal review periods to assess the employee's performance against at regular intervals during the PIP. Failing improvement to performance, then again, formal warnings on grounds of substandard performance can be issued at appropriate junctures or points in time, up to including termination of employment for repeated or continued substandard performance. Consultation process and key steps at a very high level. So step one is that the employer really should check all key documents, so the employment agreement, workplace policies, employee handbooks, and consider the framework for managing the employee's substandard performance. Again, refer to the ebook and steps on managing a performance management process for more information. It's very detailed, comprehensive, and very helpful. The second step, ensure that informal measures have been implemented to address performance concerns. So the employees has had an informal opportunity, and the proposal to implement the PIP is not going to come out of any or bolted with blue to the employee or anything like that. Step three, then you're formally consulting with the employee about the possibility of implementing a PIP, including the measurables and how the employer proposes to measure, monitor and assess their performance, and hearing what the employee has to say. They have the legal right to give their feedback in relation to any proposed PIP before it is set. Step four would be implementing the PIP, provided that the employee is not giving any clear or crucial feedback which would amend or warrant changing what goes into it, and formally reviewing the employee's performance at regular intervals, like I said earlier. And if the employee's performance fails to improve, and the employer can prove, establish, demonstrate that, these sorts of things, then potentially you're looking at issuing progressive warnings for continued substandard performance. And then the final step, step five, if the employee's performance fails to improve by the end of the PIP, then considering termination, and termination in these circumstances would always be on notice for repeated substandard performance, and that would go off the back or the basis of repeated warnings, which would have been issued during the context of the PIP, up to including termination on notice. And again, use Employer Pro's step-by-step guidelines, template letters, and the documents that we have available. Pro's resources. Like I said earlier, Employer Pro has a range of resources and tools available to help employers, from comprehensive ebooks including step-by-step guidelines and commentary, concise practical employer toolkits for managing key employment processes like a performance management process, template letters and documents, webinars and training videos like the one you're listening to now, employment documentation, for example, Employer Pro employment agreements and workplace policies, which have been drafted to be legally compliant and very pro-employer or employer friendly, and then access to further advice via advisory consultations or hands-on support like representation if required via formal consultancy arrangements or terms of engagement. Practical hints and tips. If you're an employer who's considering or grappling with a performance management process, so always check the employment documentation carefully, namely the employee's employment agreement, any workplace policies or procedures, employee handbooks, etc. Consider how those documents or obligations may inform what you need to do as the employer to manage a formal performance management process. Consider the framework for addressing the performance concerns. So informal steps and formal steps, what do those look like? Like I said earlier, the ebook on performance management has some very detailed, useful information and practical resources in it for managing both of those steps. So informally, there's some the informal stage, there's some commentary in the ebook around what that looks like as an example, including practical commentary and a template letter of expectation that an employer can send to the employee to batch or categorize the performance concerns, and consider an informal structure to try and help lift the employee's performance and hopefully avoid having to implement a formal performance management process. These sorts of things which are very helpful. Ensure, if implementing a PIP, then ensure a formal consultation with the employee about implementing the PIP before it's set. So this is a really fundamental or basic requirement that's often missed by employers. Often the mistake that we tend to see is the employer will just set or implement the PIP or just even issue warnings, say, without any process following that. There's a legal requirement that an employer must consult with an employee about implementing a PIP, including what measurables or objectives that the employer proposes to put in the PIP to assess the employee's performance. The employee must be given the opportunity to comment on any proposal to establish a PIP before it's set, including all your other procedural fairness considerations like advance notice, information in advance, opportunity to seek independent legal advice, bring a representation support person at any point in the process, including to the meeting to talk about establishing PIP, these sorts of things. Again, Employer Pro's resources and the templates, the commentary has all the stuff embedded into it by default, which is very helpful. The PIP any PIP needs to be well drafted. And again, this is something that employers often overlook, but need to think about very carefully. How is it going to put the measurables into place? Are those clear? What's the structure associated with the performance review process going to look like to assess the employee's performance against at regular intervals during the PIP? These sorts of things need to be planned, mapped out, and thought about before actioning a PIP. The employee must be informed of their legal rights, and I mentioned this before, along with any potential outcomes associated with the PIP. So the short point there is that the employee needs to be aware or understand that if the PIP is implemented, then following progressive warnings at regular intervals or junctures, if their performance fails to improve, then their employment is potentially in jeopardy on grounds of substandard performance, for which they could face termination of employment on notice. So again, read Employer's ebook, a comprehensive ebook on managing a performance management process. Use the template letters and documents and follow the step-by-step guidelines and instructions. Very useful. In terms of general disclaimers, this webinar is for guidance and information purposes only. It does not constitute formal legal advice. Employer Pro Limited is not responsible for any liability or otherwise arising out of the use of this webinar. Seek professional advice or support from Employer Pro by becoming a member today if further assistance or support is required. Employer Pro, supporting employers. Visit www.employerpro.co.nz or email info@employerpro.co.nz for further information or assistance.